Good afternoon, and thank you all for joining us today for what we hope will be an interesting and useful session. We plan to speak for about 45 minutes or so, and then we'll take your questions. So as Tamar says, please do just pop your questions in the Q&A as we go along, and we will see what we can get to towards the end of the session. I'm joined today by Yvonne Spencer. We're both partners in VWV's education team and have a combined experience of over 30 years advising the firm's school and education clients. I'm also delighted to introduce our guest speaker today, Miriam Carrion Benitez. So Miriam's an education law barrister with over 20 years experience representing education settings, parents and local authorities in respect of equality education and human rights matters. She was actually counsel for the interested party, Brent London Borough, in this case, the Michaela case, so has some insights that she's agreed to share with us all today. So we've got quite a bit to get through for you. So without further ado, I will make a start. So the question that this case considered and which this session will focus on is, to what extent can schools and colleges ban pupils from taking part in prayer or religious rituals on their premises? Okay, so Miriam, can you tell us what the case is about and actually how you came to be involved?
Thank you, James. Yes, I can, and hi to everyone. So this case is about a pupil, a single pupil, who challenged the school's decision to ban prayer rituals in the school, specifically in the school playground. There was no prohibition at the school, but it had not been expressly allowed either within the policy documents. So specifically, this pupil had wanted to pray during the lunch period, which in those months coincided with one of the 5 prayers that are prescribed by Islam. And she was, as a result of her praying in the playground and a confrontation that ensued with a teacher, she was suspended for being rude to a teacher when she was asked to put away her prayer mat. And then later she was suspended a second time for threatening to harm members of the school. The governing body thereafter upheld the head teacher's decision in respect of both these suspensions, and also upheld the prayer ban on the basis that to allow the prayers to continue would be harmful to the ethos of the school. I have to say also, James, what this case is not about. And this case is not about whether the judge, or indeed, I won't be talking about that myself either, whether the judge agreed with this specific head teacher's approach to behavior or the ethos that she imposed at the school. So the judge did not go into whether that was right or wrong. And the head teacher herself was very clear throughout the proceedings that she was not professing to be right about everything. She was just simply saying, this is the way I do things. Everybody knows how I do things. And this specific pupil knew the secular ethos of the school before she joined us. Equally, the judgment and the case is not about whether the pupil was right to believe that she could make up the prayer later on in the day. The judge was quite clear that she would not make any findings on whether Islam allowed make-up prayers at another point of the school day or of the day, the natural day, and narrowed the case to legal issues. I am going, James, just for clarification, I will be referring to the prayer ritual policy as the PRP throughout this talk. So that's the ban of the prayer rituals at school, and all rituals were banned and not just those covered by Islam. Thank you, James.
Thank you, Miriam. So, I mean, this case and perhaps the school attracts a lot of attention. So we've all read news reports, and there's lots of details that are sort of interesting, but perhaps salacious. So, I mean, what really happened, and was it as has been reported?
It was broadly as it has been reported. I think the judge was very, in my view, very cautious not to stray into matters that could have upset race relations in the borough and in the school. He was very careful not to further inflame an already very hot situation, and therefore I think he left out some of the more fallacious, as you said, or unattractive elements of the claim, left the detail out of the judgment, in my view, quite rightly. So in terms of what happened, I think it's necessary to provide some context on both the pupil and the school and the unique nature of both parties to this claim, because we will see that it really influenced the way in which the court dealt with the issues. So the three main things that make the facts of this case unique are this. Firstly, the school had very, very strict behavioral policies and a very distinct ethos that prioritized the team over the individual. And this applied across the board to race, religion, any other differences. The idea was that the school community was a cohesive school community. The second point was the makeup of the student population of the school, with it was 700 students, and over 350 of those students were Muslim. And the location of the school were in Brent, which 65% of the population in Brent are Black, Asian, or other ethnic minority. And that's the second highest rate in England and Wales after Newham, which exceeds it by 3 points. The judge was also very conscious of that when looking at the issues and considering the issues. And the third point that I think makes this case quite distinct was the level and the nature of the threats made against the school and individual teachers at the school following the petition that ensued after the suspensions, etc. I will talk a little bit more about that later. Indeed, James, the judge, in the first line of the judgment, says, or is at pains to emphasize, that Michaela School is a secular school, highly successful, high level of control over the pupils, and it is one of the it is placed in one of the most diverse London boroughs, where the majority of the pupils are from diverse ethnic and religious backgrounds. So right at the outset, the reader knows that this is very factor specific, and we're looking at a set of facts that are highly complex in the context of religious freedoms. These first two paragraphs I view almost as a cautionary statement of what will follow in the judgment, and they mirror the first paragraph in the Supreme Court decision in Shabina Begum. Shabina Begum was Yvonne's case, I have to say. She succeeded in the High Court representing Shabina Begum. And in that case, which revolved around the wearing of her jilbab, I think it was jilbab, the Supreme Court said at the outset, and I'm going to read this because it's quite important to put this in context, that this case concerns a particular pupil and a particular school in a particular place at a particular time. It must be resolved on the facts which are now, for the purposes of the appeal, agreed. The House is not and could not be invited to rule whether Islamic dress or any feature of Islamic dress should or should not be permitted in the schools of this country. That would be a most inappropriate question for the House in its judicial capacity, and not one that we will address. So Justice Linden adopted the same approach, James. There is no ruling on whether praying outside of the prescribed times would be against Islam. And that's why the judge really stayed well away from that issue. Now, with regards, moving on to the claimant had been attending the school since year 7, was a practicing Muslim and a female. She and her parents had not attended the open days at the school where the issue of religion had been discussed, and had subsequently not sought out any information about the extent to which prayers were allowed at the school. The incident of the prayers had not been raised by this pupil at all until the 23rd of March, which was the date of the first suspension. And her desire to pray at the school seems to have started following the visit of a Muslim head teacher to the school, who had encouraged her and other pupils to speak out on their beliefs. And that was the evidence that was not entirely agreed by all the parties, but somewhat uncontested. Now, with regards to the Michaela School, I think you all know, you've seen the news, BBC News, everybody knows the head teacher, but in the judgment, there is a brief summary of what it is. So it's the strictest school in Britain. That's what the head teacher professes it is. Has exceptionally good academic results. For those of you who are in education, this will mean quite a bit, but in 2022, the head teacher said that they had a progress 8 score of plus 2.27. That's the highest ever recorded since the measure was introduced, she said in her statement. That means that on average, children at the school achieve more than 2 grades higher at GCSE than they would achieve at an average school. The school is also located in a former office building. This was important because the court was looking at whether the prayers could have been allowed in other areas of the school, and this wouldn't have posed particular difficulties. But this particular building was very short of space and logistically presented difficulties that had to be very carefully managed. The head teacher at the hearing said, when I say she said, she didn't actually give evidence, but she said through her witness statements, there was no cross-examination of anyone at the hearing. It was all done by way of witness statements. So the head teacher said that up to 12 rooms on her estimation would be required to be made available during the lunchtime to enable indoor prayers. Now, in terms of the school, and James, this is a bit of a longer answer than other questions, so bear with me. But in terms of the school, I think we need to talk about 2 aspects, specific aspects of the educational practices, policies, and the overall ethos. The first one is the strict behavioral policy. The head teacher said that unless there was a rule at the school that unless something was explicitly allowed, it was prohibited. You will have seen, many of you, the photographs of children walking in single file, etc., and what they're permitted and not permitted to do in school. One of the things that the school doesn't permit is free speech amongst the children. To some extent, they call it the Michaela full stop. So that's the prohibition of speaking to more than 3 other pupils at any one time, at any point during the school day. They're also required to chant poetry, to sing the national anthem, which is broadly Christian in its nature. And they can only speak at the lunch table about prescribed topics of conversation. The school also said that there was a level of social engineering that took place during the lunchtime. So the pupils are directed to socialize only with pupils in their year group. And within that, the teachers will break them up if they feel that they are clustering along race or religious divides or any other divides, and mix them up. They call it guided socialization and professional play time. There is no free time. That was the evidence of the school at the hearing. The teachers are also in unquestioned positions of authority. One of the things that harmed the school's case in relation to the second exclusion was that the head teacher had said in her statement that if a teacher has handed out a punishment to a child, that is the end of the matter. So there is no discussion. There can be no, if the head teacher so deems it appropriate, no investigation into the issues. This later came to bite her in respect to the second suspension. So with regards to the ethos, the school community was said to take precedence over the individual, and this applied to all religions. And the ethos was to build friendships across all faiths and not to allow segregation of any kind. And in the context of that backdrop, James, I'll look now at the genesis of the claim. So the school, you may have seen the photographs in the media, but the school's playground has a fence, and you can see what's taking place in the playground from the street. It seems that some members of the Muslim community saw the children praying on wet ground from the street, and they were using their blazers. Thereafter, a head teacher of a Muslim school attended the school. He came with a group of women wearing burqas and hijabs. They spoke to the pupils. They spoke to this pupil in particular, it seems, and to another group, and they suggested that they could pray in the yard if no prayer room was allocated. The yard praying started, and it escalated to, it went from a very small cluster of students to about 30 students. Then that led to the first suspension for extreme rudeness towards a teacher when a specific pupil was asked to put away her prayer mat. And on the 24th of March, so the first suspension, was imposed on the 23rd of March. On the 24th of March, an online petition appeared that eventually gathered over 4,000 signatures. And within that petition, comments were allowed, and other comments appeared all over social media that were highly abusive to members of the school and to the head teacher. On the 27th of March, a day after the petition, there was a threat that a bomb had been planted in the school, etc. And then on the 27th of March, the head teacher banned the prayers. This term, end of term school trips had to be cancelled. Easter had to start earlier. And then in May, the governing body endorsed the ban on prayers. One of the things that was of great concern to the judge in the context of this claim was the conduct of some outside of the school. So there had been racist, homophobic, and anti-Semitic language used against the members of the school. And the judge noted that the teacher that told the student the first time to put her prayer mat away was a Black teacher. There were references to lynching, slavery. It was very unsatisfactory and threatening language used, inappropriate language used in respect of this teacher. There was also evidence at the time, and this is not dealt with in the judgment. So the judge didn't feel that he needed to make findings, but there was evidence, the head teacher said, that some pupils were being intimidated or pressured into praying, particularly during Ramadan. Some facts were not accepted, James. For example, it was not accepted that the online petition, as the head teacher maintained, had been instigated by this pupil and her mother. It was also not accepted that the actions of the school had been racially motivated, or that the pupil had been made to feel that she doesn't belong in the UK. That was one of the assertions that she made in the statement. The statements in this claim, I have to say, I've been doing this many years and I've never seen statements that were so emotive and so highly charged as in this case. And the judge left out most of it from his judgment. So, James, those were the facts.
Thank you. That's that's really clear. And I mean, this sort of idea of the sort of tinderbox issue, I think, is why this case is so fascinating and clearly mirrors some very challenging issues that we are seeing played out in lots of different ways across society. So, I mean, get to the boring bit now, I suppose, in some ways. But what were the legal issues involved?
The legal issues were quite simple, I think. So 3 main legal challenges against the PRP, the prayer ritual policy, which is the ban. 1, that the policy breached the right to freedom to manifest her religious beliefs under Article 9 of the European Convention. The second issue, that the policy indirectly discriminated against all Muslim pupils on the basis that it caused a detriment to them, and it was unjustified. And the third issue was that the school had failed to have regards to the public sector equality duty when introducing the ban, in particular, the need to foster good relations amongst all groups at the school. Then there were 2 further claims against the suspensions. Those are more, I would say, they're the more sort of pedestrian claims, the ones that you see often in this sort of claim. The objection to the PRP by the pupil, so they're not being able to pray during lunchtime, was quite narrow. What she said was this: she said that she couldn't make up the lost prayer after school because Islam didn't allow her to do that, and that making up for prayers was an exception and couldn't be made into a rule. And that given that, in her view, she was perfectly capable of praying during the lunchtime, she should be allowed to do so. She said that lunchtime was free time. There was dispute on that. The head teacher said lunchtime wasn't free time, and it was guided social time. The school said no breach of Article 9, no breach of the Quality Act, because that served to further or protect the school's ethos. and it was justified. It also said that the school had sufficiently considered the public sector's quality duty. And in relation to the suspensions, the school said that there was no breach of the duty to act fairly, and that if there had been a breach, the outcome would have been the same. So I guess in terms of the Quality Act, the main argument there was that the ban subjected the pupil to a detriment in that she had to forego her wish to pray at the required time. And she also argued that she would be placed at a particular disadvantage, and the school could not show that the ban was a proportionate means of achieving a legitimate aim, which we will talk about more later, James.
Thank you, Miriam. So, I mean, the school was school's a state-funded school. So, to what extent do these legal issues, specific legal issues, apply to all schools? I mean, we're joined today by independent schools as well as schools in the academies and maintained sector. So, it would just be interesting to pull out any distinctions. Yeah, so the Equality Act, as we know, applies equally to all the schools. There is the exception for, or the caveat for schools that have a religious designation, but I have to say that that exception is very narrowly interpreted under the Equality Act, and it does not protect them from a claim of detriment, because the exception does not allow the school to cause detriment to a pupil on the grounds of a protected characteristic. So it's extremely narrow. So even schools that have a religious designation have to be very careful to make sure that they don't fall under the broader detriment anti-discrimination provision of the Equality Act. In terms of the Human Rights Act and the public sector equality duty, this, as you know, James, do not apply to independent schools unless it can be said that they're exercising public functions. I had another trawl, yet again, at all the case law on exercising public functions, and in the context of the schools, there's very little case law, and the only case where there was an affirmative finding was the Cobham Hall case where the school had participated in the assisted places scheme under the Education Act, and therefore was exercising public functions and was said to have to comply with the Human Rights Act. But other than that, it does not. There is an argument, James, I think, that hasn't been taken to the courts yet, that the promotion of fundamental British values may amount to a public function, and therefore independent schools may be caught by the Human Rights Act, but it's not something that has been argued. With regards to public sector equality duty, again, applies to schools as in public functions, which generally has held to mean state-funded schools and not independent schools. However, James, there is, in my view, a degree of overlap between the public sector equality duties on the one hand and the other duties in the Equality Act. And my advice always is that when a decision maker follows the public sector equality duty, it's very rare that they haven't followed their duties under the Equality Act. So it's a good guiding light, or sort of North Star for everyone, I think, to look at the public sector equality duty and make sure that you're following it, even though you may not be legally required, such as independent schools. Thank you. And of course, independent schools are subject to the independent school standards, which also contain positive duties around, promoting integration between pupils and protected characteristics. So I think, yes, that overlap is very apparent, isn't it? So getting down into sort of the weeds a little bit here. So what's the difference between freedom of religion and the freedom to manifest a religion, and why is that important? Yeah, so there is one fundamental difference without going into the more nuanced analysis, but so the freedom of religion is a fundamental right. You can't derogate from it. So everyone is free to hold the beliefs that they hold. The freedom to manifest your religion, the belief that you hold, is qualified, is not an absolute right. And it's qualified, it has been qualified by case law to mean that no one has the right to manifest your religion at any one time, at any one place, or in any manner that accords with your beliefs. So we can impose restrictions on how somebody manifests that belief, but we can't impose restrictions on the beliefs.
So, and that's why this case is arise in the context of religious freedoms. It is generally in the context of manifestation of a religious belief in countries, democratic countries, what we have to say there.
Yes.
Yeah. And the way, sorry, James, my fault there. The way that it has been qualified is that it generally it is said that if a person, and this was held in the Shabina Begum case, that if a person has a choice and first of all has made an informed choice to join the organization, be that an employer or a school, and then has a choice to leave and go elsewhere, study or work as well, then it would be permissible to restrict the right to manifest religious belief by that employer or that school. So the question of choice was also very central to this judgment.
Thank you. Sorry for the the premature interruption there, Miriam. So in the context of Article 9, the ECHR, why is this case important?
So this case was very important. I think we were all hopeful, and I don't mean hopeful of a particular outcome, but I think we were all hopeful that this would change the landscape somewhat and provide some more guidance between the tension of the Shabina Begum judgment, which says that if you have a choice, you can exercise that choice and any restriction may be permissible. And another case in the European Court of Human Rights, which is the Evada case, we call this the Evada principle. What the Evada principle says is that the element of choice doesn't do away with your responsibilities under the convention. It should be placed in the balance alongside everything else that you're considering when looking at proportionality. But Justice Linden in this case preferred and followed the line of authority in Begum. And therefore, the position today continues to be that if a complainant has a choice and exercising that choice, so in this case, leaving the school and going elsewhere to be educated, would not bring about undue hardship or inconvenience, then there will be no breach on the freedom to manifest one's religion if restrictions are imposed. I hope that's clear, James.
Yes, it is. That's really clear. Thank you, Miriam. So, I mean, we talk a lot about proportionality. Proportionality is a term lawyers throw around, and but what it essentially means is it comes back always to the practical considerations around decision making, essentially. And the court obviously spent a lot of time discussing proportionality, whether the ban was proportionate. In practical terms, can you explain what makes a decision proportionate?
Yes. So proportionality, you're absolutely right, was central to the case, and the case spent most of its time looking at proportionality, and then very little time looking at discrimination on the grounds of religion, because it said, well, I've already been by findings in proportionality, the same reason applies. So yes, all decisions have to be proportionate in the context of a restriction of rights, and 4 questions are asked. I think it might be best, James, if I tell you what the questions are that all decision makers must ask themselves when reaching a decision of this kind, and then I will illustrate it with the facts of this case. So these are the Bank Mellat questions, and that was a case quite a while back. So the first question is whether the objective of the measure is sufficiently important to justify the limitation of a protected right. In this case, the measure was the ban. And the importance, the judge found, was the preserving of the policies, ethos, and practices of the school, including preserving the cohesion. So that's the first question. The second question is whether the measure is rationally connected to the objective. So in this case, the ban was connected to the objective in that the head teacher thought that it would further the behavior policy and it would avoid segregation and peer pressure. And she reasoned, and the judge accepted, that after the ban was imposed, everything went back to normal. And there were no further disputes at school, and students could study without being pressurized, intimidated, and there was no more segregation in the playground. So that was the connection between the ban and the objective. The third question is whether a less intrusive measure could have been used. And I think all educators that are in this talk will be used to looking at whether a lesser sanction can be applied, for example, in the context of suspensions. In this case, the judge found that there couldn't have been a lesser measure because this was difficult due to logistical difficulties, the building itself, the fact that 12 rooms would be required or more, and also the level and effort and costs, the staffing requirements, and the configuration generally of the building. So that is the lesser sanction question, as I call it. And the last question is how the interests of the one party weigh up against the interests of the other party in trying to achieve what you're trying to achieve. In this case, the interests of the school outweighed those of the pupil. The judge thought or found that the pupils had chosen the school in the first place, and they knew of the strict behavioral policies and the ethos, and they had then chosen to remain at the school despite the prayer ban. She said that nobody had contacted her wishing to leave the school. The head teacher also said that, I've already talked about this, that good relations were restored after the PRP was imposed. So, and one point to mention with regards to the proportionality here, and this is perhaps a bit of an aside, but the day after the judgment, the Central Mosque Trust, the London Central Mosque Trust and the Islamic Cultural Centre issued a statement. And one of the things that they said in that statement is publicly available, I believe, on Google. But one of the things that they said in that statement is that the head teacher has said that she would give permission for the kids to pray at the Civic Centre across the road. And they meaning the trust and the centre, welcome this measure as an overall solution that the kids would be able to successfully pray. So that they thought that that would do away with any concerns under either the Equality Act or the Human Rights Act. Thank you, James.
Thank you, Miriam. So, I mean, I think you've explained that essentially the court looked at proportionality in the context both of the human rights claim as well as an indirect discrimination claim. It essentially boiled down to that same analysis in terms of how you get to a proportionate decision. So in the interest of keeping this to time, I'll move on to a question about the public sector equality duty, which I think is an interesting duty, and it would be useful if you could just explain what it is and how that applies to schools.
Yes, of course. So the public sector equality duty is embodied in Section 149 of the Equality Act, and it applies to public authorities listed in Schedule 19. It ensures that all public authorities consider how then functions, that's everything they do, whether it's the provision of services or decision-making, how it will affect people with different protected characteristics. And in doing so, they have to have due regard to eliminate discrimination, harassment, victimization, or any other conduct that is prohibited under the Equality Act. They have to advance equality of opportunity between the persons who share the relevant characteristic. They have to foster good relations between persons who share a protected characteristic and persons who do not share it. Those are the three aims of the duty. Having due regard hasn't been defined in the statute and is not defined in case law definitively, but it encompasses some general principles. In this case, the case was mainly argued on the basis that the governing body had not had due regard to the equality duty on the basis that they were not, the decision to ban prayers did not tackle prejudice or promote understanding, which is Section 1495. In terms of the principles that the judge reminded us about, perhaps to highlight just a couple, which is that the public sector equality duty cannot be applied with hindsight. It has to be applied at the time you're making the decision. And it has to be integrated into the carrying out of the school's functions on an everyday basis, cannot be delegated. And if there is not enough material to decide whether you are complying with it, then you have a duty to go and get that material. James, that's a very whistle-stop summary of the public sector equality duty.
Thank you. No, that's great. And of course, I think as you've alluded to, it doesn't apply directly to independent schools. I mean, let's come now to the real meat of this. What was decided, and what were the reasons given for that?
So the judge dismissed the claim on all grounds except for one. So judge found that there was no breach of Article 9 because it did not interfere with her freedom to manifest her beliefs for three primary reasons. The first one is that when she enrolled the school, she knew about the strict behavioral policy, and she knew about the ethos. And she knew that she would be subject to restrictions on her ability to manifest her religion. In any event, the judge went on to find that even if she hadn't known at the time she joined, she knew thereafter, and that didn't provide her with a defense. The second point that the judge found there was that she could perform the Kara prayers after school, and that is there is a view reasonably held by some members of the Muslim community, and that he didn't need to find any more than that. And also found in respect of Article 9 that the ban was justified given the ethos of the school. With regards to the Equality Act, the judge, unsurprisingly, found that there had been detriment in not allowing her to pray when she wanted to pray. The judge then said that a finding of detriment is not enough, and that he needed to consider whether the ban was proportionate. A proportionate means to achieve a legitimate aim. And for the same reasons as for Article 9 that we've talked about when I talked about proportionality, he found that any disadvantage to a Muslim pupil at the school was outweighed by the aims of cohesion and inclusion, which lied at the core of the school's ethos. With regards to the public sector equality duty, again, no breach. There had been adequate consideration. And I think that's it. Well, with the suspension, so one of them was not upheld, and one was upheld. I can talk about the suspensions a bit later if you like.
Well, you've preempted my very next question, actually, Miriam. So, I mean, actually, in relation to one of those suspensions, why was one upheld and one not?
Yeah, so it's quite simple to answer. The suspensions were different. The first suspension, which is the one that was upheld as a valid suspension, was because the student had been rude to a teacher. The teacher had given evidence to the head teacher. It was uncontroversial, and it was accepted by the student that she had been rude to the teacher. So there was no scope for arguing procedural irregularity, for example, that her views were not sought, etc. However, in relation to the second suspension, there were other pupils involved, and only one side was heard, and that's the people that said that the claimant had wanted to stab her and had said to her that she was going to destroy the school, etc., etc. And in respect of that, the head teacher did not ask the claimant for her views, did not conduct any more of an investigation, and suspended the claimant for 5 days and then placed her in isolation for a further 5 days for openly talking about wanting to do harm to the school. So a few comments on the on why this second sanction was found to be flawed and unlawful. The first one, the judge said that the more severe the sanction, the stricter the duty to act fairly. That's a principle of natural justice, and to give both sides a chance to comment. The events had taken place a month prior to the suspension, so that there had been a lapse of time with the possibility for error on the side of the pupil reporting these statements. The judge clarified the suspensions guidance, which I think is quite important. So the judge said in the suspensions guidance that there is some vagueness. It was argued as to whether the views of the pupil should be always taken into account or only taken into account in the event of a permanent exclusion. The judge said they have to be taken into account in all cases. And he did say, which this might be a little bit painful for the DfE, that the suspension policy is not well drafted at all. And that nonetheless, despite the shortcomings of the suspension guidance, it is striking. The judge said that the head teacher did not refer to the guidance at all in her two witness statements or having had regard to it.
Thank you. I think that's really really clear. So, I mean, I think everybody will probably agree that the outcome was a little surprising. I mean, can we expect an appeal, and to what extent will this judgment be followed in other cases?
So we know there's not going to be an appeal. The reason why I think the claimant's not appealing this, and I'm surmising, I don't know it for a fact, but I think it's because counsel for the claimant realised that this case was highly fact sensitive, and that it's not very good when you're trying to set precedent or move the law along to have such a highly fact sensitive case. So, but they have communicated to us that they're not going to be appealing the decision, and it will have to be followed by everyone until somebody else challenges it.
Excellent. Although, of course, as you've said, it's highly fact specific, so the extent to which the principles will read across into other cases is reasonably limited, isn't it? Okay, so I mean, we'll bring everyone in here and see, you know, see whether we all have some thoughts on these questions. But so, I mean, does this judgment mean that schools can be confident in prioritising their aims over individual rights? I mean, I think this is a really sort of crucial issue for schools trying to make that balance. Yvonne, do you have a view on that?
Yes, I do. Thanks, James. And thank you to Miriam for that presentation. So just thinking about that question, I just want to break it down a bit. So I think where that confidence comes from this case and the decision, is that I think schools can be really confident in their right and ability to have a clear ethos and to have clear aims, and to be able to consider those in its decision making. So I think that's where the confidence should really come from. And then being clear about their aims, their ethos, their culture, etc. When faced with a situation where you're required to think about whether an individual's rights should be restricted, where it comes into conflict or impedes the institution's ability to implement that culture and ethos, then I think as long as the school looks at the question of whether there is no other way to achieve those aims, ethos, culture, etc., then it gives you a framework with the benefit of that confidence in which to decide, you know, is the restriction going to be a proportionate means of restricting the rights? So I think that that's where the clarity and confidence should come from in terms of the takeaway from this decision. And I also think, you know, some of the reasons that Miriam's articulated there, you know, particularly for state-funded schools, the public sector equality duty is something that is frequently inserted into complaints, threats of claims, etc. And it was really helpful in this decision just to see how the courts deal with the public sector equality duty. And they talked about, you know, clearly it's not a checklist, but if you have a really well-reasoned decision, then the courts can look at that and give, you know, a certain degree of deference to it. So I think that was helpful as well. So I'm really speaking to the confidence piece of your question, but I think that, you know, those are points for giving schools confidence.
Thank you, Yvonne. Yeah, I would absolutely agree with that. And I might, I suppose, just to add the caveat in terms of the aims themselves. I mean, this is what it will all come back to, and we'll certainly talk a little bit more about this in a minute. But I think that schools who are clear and considered about what those aims are will already have thought about the interests of their community and striking what would be an appropriate balance. So that's a really good starting point. And I think if that has been your starting point, then there is some confidence, the real confidence that can be taken from aspects of this judgment about getting that balance right and not being afraid to pursue your legitimate aims. Miriam, do you have anything to add to that?
I entirely agree, but your aims and ethos need to be traceable. So you can't tell someone your aims and ethos later in the day. They need to be somewhere in writing. They need to have been communicated either through assemblies or meeting with parents, etc. So just to be clear, and whenever you're trying to depart or restrict a right, then it is really important that you have a track, that you can track that decision-making process and pin it to a point, and our communication to the parents. So that sort of flow of communication, very clear and consistent, is very important in the context of rights.
Thank you. Yeah, completely agree with that. So, Yvonne, should we just pull out the differences in learning points between the state and independent sectors? I mean, what's your view about that?
Well, I think from both sectors, I mean, clearly this was a state-funded school, and so the Article 9 and the certainly the public sector equality duties really resonate with the state-funded school sector. So I think that speaks to a lot of it. I also just, and I don't really feel I need to elaborate on some of the points that Miriam has explained to us, but there is just this point that I think of a point of difference, and that is where we've talked about suspensions and we've talked about the suspensions and exclusions guidance. That guidance is addressed to academies and maintained schools. So for the independent schools delegates that are on, have joined us in this webinar today, that is not a document that applies to them. And so it's important to think in terms of the procedure and the criticism that Judge Linden made about the quality of that statutory guidance, which I know that I and our colleagues would endorse. I think that's something to think about, although there are some really good principles from this judgment around sanctioning pupils, such as the more serious the sanction, you know, the more rigor would need to be applied to the decision. But there are distinct processes that arise through that statutory guidance that don't apply to independent schools.
And I think, James, if I may, I think that's why it's really important that independent schools, above any other school, are really clear about their aims and ethos and how they're going to conduct themselves through a very good and robust behavioural policy. Because you don't have that statutory underpinning through all of the DFE policy, guidance documents, etc.
Yes, absolutely. And I mean, in terms of the differences, I suppose in some ways I was struck that when you really get down to the analysis, how few differences there are actually, because although you don't get the direct application of human rights law, you don't get the direct application of the public sector equality duty, so much turned on that proportionality of decision making, so much turned on the clarity of the school's approach and ethos. And I think that from my perspective, some of the key messages are essentially the same, which is, you know, we're talking about a very difficult balancing act. So, you know your community, be clear about your aims, and this will manage expectations and help with clarity of thought and purpose in striking that lawful balance. And perhaps, I mean, you know, one distinction would be that, you know, independent schools, whilst they are possibly in a more difficult space where they don't have the statutory guidance to rely upon, that's also an opportunity from another perspective to ensure that actually you really are reflecting what you want to do and who you are as a school, and ensuring that that's reflected in policies as well as practice. So this is key to me, but ultimately as well, one of the things that I thought was really positive about the judgment is that there was a strong message actually that came across from the court's deference to the professional judgments that had been made that had underpinned a lot of the decisions. And so, you know, actually be confident in the matters in which, you know, you are the experts, your school, and your assessment of the issues and the risk assessment on the grounds, because the courts will give that due weight. It's really just about making sure that there are considered decisions being taken, and well-drafted policies, and particularly with disciplinary matters, are going to help you with a fair and effective process, and that will actually ultimately help to ensure you have the information you need to come to informed decisions. And I think that was the crucial distinction between the two suspensions. Okay, we are just.
There are some questions there. I've just seen,
yes,
James.
I was just about to dive into the questions actually, as we are now starting to run a little short in time. So
I think 1 and 2 are both uniform related questions. 1 and 3, sorry.
yes, did you? Yes, please do, Miriam.
No, that's okay. Sorry, I can only see 3 questions. There may be other questions. So yeah, I see a question here from Alan and Oliver. They talk about, for those of you who may not be able to access the Q&A, how does this judgment relate to other considerations where religious manifestation can be a factor, for example, uniform policies? So it relates square on, really head on.
Yes, it does.
And hence the analysis of the case of Shabina Begum in this case, and Shabina Begum was a uniform policy, as it were, case. So yes, you will have to go through the same public sector equality duties. You would have to analyze whether changes to your uniform policy or whether your current uniform policy is causing a detriment to a group with a protected characteristic, and carry out that sort of Equality Act impact assessment almost. And if you want to introduce changes to a uniform policy that already exists, or a policy, that any other policy that already exists, then my advice is always that where the changes are likely to impact a group with protected characteristics, so for example, when you want to make your uniform policy more strict, then you must carry out a consultation with your community. And even though in the independent sector consultations are a slightly different animal, and there is less practice perhaps of carrying out consultations, I still think they're important, because under the detriment test of the Equality Act that does apply to independent schools, in this context, you'll be looking at the impact of the decision on the pupils, and you can only show that you've considered the detriment if you know what the impact is, and that can only come about after consultation.
Great. And on I mean, I completely agree with that. And on a sort of more practical level, I mean, I often think with independent schools, if you are putting together a policy that is essentially, and this sort of goes back to your legitimate aims, that is looking at trying to strike an appropriate balance of rights, how are you going to know what you're dealing with unless you've actually consulted? So, you know, it's a really sort of common sense point. I absolutely agree. And one of the things I thought was really interesting and possibly quite valuable in this case was some detail that emerged about the school's own uniform policy. So they had a very strict uniform policy in line with their strict approach generally, but they did make exceptions. So one of their exceptions was for items of religious significance. And of course, I think there's always some concern about having exceptions and then managing those in a way that doesn't start to sort of take on a life of its own. So the way the school approached that was that items of religious significance were permitted where they were required as a matter of sincere religious observance, and it had to be substantiated by a letter from a leader of a relevant religious community. Now, that struck me as actually a really sensible piece of practice, and something that that schools can take away perhaps as a practical point. Okay, so other questions. So please, could we revisit the reasonableness standards, please? So I'm not sure precisely what that refers to. Has anyone got any thoughts on that?
I am not sure either, James. I'm sorry, I thought it was just me being a bit slow. Perhaps
No.
if the person asking the question wants to clarify.
I mean, I wonder if that is possibly a question about proportionality again, and getting that balance right. I think, however, I'm sorry to say, as this has been a fascinating session for me at least, that our time is up. So apologies we didn't get to that final question. Thank you all for joining us, and thank you so much to all of our speakers, and particularly to our guest speaker, Miriam, Kerry and Benitez. So thank you so much.